Good morning to everyone. This is Dr. M.R.K. Prasad, Dean Faculty of Law, Goa University, also Principal of UM Silgaonkar College of Law, Panaji, Goa. I hope you have learned a great deal of access to justice from previous modules, and you have learned a lot that legal aid is one of the tools for the access to justice, and we realize the importance of legal aid as a tool to improve the access to the justice to the masses. Therefore, the last we are having 3 modules again on access to justice through legal aid, and we have already learned how the access to justice was promoted by the legal aid developments prior to 1970. To learn a great deal about legal aid, how it brings access to justice to the masses, we had 3 modules kept on that. You have already learned 2 modules on legal aid. One is the developments prior to 1970. The second module focused on the developments from 1970 till 1976. The third module, which I am presenting today for all of you, is on how the legal aid developments provided access to justice after 1976. So today we would be focusing mostly on the developments that took place from 1976. What is the object of this module? The basic object of this module is primarily to analyze the experts committee report on national judicature, equal justice and social justice. After focusing experts committee report, we would also looking at the suggestions made by the committee for implementing the legal aid schemes. Then after that we will see how the recommendations of these both committees was transformed into a national legislation. So by undergoing these 3 modules, I would say the 3 components of this presentation, you would really appreciate how the legal aid, which has started as schemes from the state, has become a statutory obligation from 1987 onwards. The access to justice concept was formally introduced in India by the Bombay Legal Aid Society, as we learned in the first module, that is the developments before 1970, and subsequently the Bombay Legal Aid Society's recommendation. There were many other committees has made recommendations. You could see on the slide that the West Bengal Legal Committee, then 14th Law Commission has discussed a great deal of how the legal aid should be secured by the state. Then there are many other reports from different states, and then which ultimately lead to a constitutional amendment in 1976. The 42nd Amendment made it a directive principle of the state policy to provide free legal aid as an obligation on the part of the state. So the access to justice through legal aid has received a great deal of discussion, not only from the state but also from the academia and also the other stakeholders. However, one of the fundamental problem that was faced in implementing the legal aid schemes as suggested by different committees is one, the financial problems, and also the problem of no uniformity in India. Therefore, an expert committee was established in 1977, and the committee has given a report. We are looking at that the recommendations of the report of the expert committee, National Judicare, Equal Justice, Social Justice, and the committee recommendations, we would be focusing mostly on the uniform legal aid program throughout India, and also it looked the another challenge of how do we recognize this legal aid program and institutionalize this legal aid program in India. So the basic task of this committee is to uniform implementation of legal aid programs, and there were certain hindrances to achieve this. Therefore, the committee also highlights the need for statutory provisions, making legal aid as an uniform process throughout the country of India. So after these recommendations were made, the recommendations were well taken by the state, the government, and this led to the enactment of Legal Service Authorities Act in 1987. However, due to certain reasons, this act could not be enforced immediately, and to identify these problems, there was a conference was called to make suggestions under the chairmanship of Honorable Chief Justice of India, and finally it has given certain recommendations. Though the recommendations were made, the act could be enforced only in the year of 1995. The post legal aid developments from 1976, I would divide into three components. One is the expert committee report, then the second one is the committee for implementing the legal aid scheme. The third one is bringing an enactment at the national level, the Legal Service Authorities Act. Okay. So let us talk about the first, the experts committee report that was submitted in 1977. As we already discussed, that the committee is focused more on how to implement a uniform legal aid program in India and how to raise funds. The financial support for the legal aid program is very much necessary. So the committee has focused not only on these two, but there are many other innovative recommendations were made by this committee. And the committee recognizes that India adopted democracy as a form of government, and such a democracy cannot survive without providing access to justice. And the active protection of the equal laws and the socio-economic equality could be achieved only through providing equal access to justice, and if it is not guaranteed by the state, which is actually a state responsibility, then the democracy would not survive. So therefore, the committee looks at that the access to justice is not only providing what we call legal representation at the free of cost, but also it looks at the heavy fees that are charged for resolving your disputes, and also the logistic hurdles and the early litigative finality. What I mean by early litigative finality is that the litigation cannot run for years. It has to be completed as soon as possible. So these are also part of the access to justice program. Hence, the committee not only looked at the uniform procedure for implementing legal aid, not only the financial assistance, but also the other aspects. That is the reason why the committee also felt that the theme of panchayat justice must get a primary attention. That means the access to justice should come from the grassroots level. The committee was of the view that there should be a considerable reduction of rates of court fees. As we already discussed, that it is not only providing legal representation at free of cost, but even the court fees should not hinder the people approaching the court for justice. And a blanket exemption from the payment of these fees in case of anybody who is under the poverty, below the poverty line, was also advocated by this commission. That means if a litigant is declared as a person below the poverty line, he should be totally exempted from paying the fees for his litigation. Then the committee also looks at the illiteracy, backwardness, the socially suppressed and geographically handicapped people also should be provided with the legal aid. And it also talks about providing free legal aid for the families of Jawans. And it also identified several other categories who are entitled for the legal aid, for example, women, children, even the minorities, both linguistic as well as religious minorities, who are entitled for this free legal aid.